Lordship, I have a similar prayer, item number 7,
This one also after vacation.
after vacation.
Okay, same order. Learned counsel for petitioners present. Learned counsel for
I'm for respondent number 4.
responding for Mr. Such and such present. Yes, list after winter vacation. In order to enable the state respondents to file their affidavit. Yes.
May I please, Your Lordship? Lordship, I beg to mention item number 10 and 11. Lordship, here both I am yet to receive instruction, so kindly grant me 3 weeks to file my affidavit.
My Lord, in 11, I am appearing. I have no objections.
Lordship, in item 10.
You are appearing in 10.
Item 10, Lordship.
Okay, in both same orders, learned heard, learned counsel of petitioner, learned government advocate, Mr. Attorney Sanctum prays for 3 weeks' time to file the affidavit on behalf of the state respondents. Prayer allowed list after the winter vacations. Yes.
Ali oblige.
Deeply obliged.
Please, Lordship. Lordship, I'd like to mention item number 9.
9.
Lordship.
Yes.
Lordship, I'm for respondent number 5. If this matter can be listed after 3 weeks, I need to file my affidavit in opposition.
R5. Any objections?
Similar time may also be granted to us also. I am for respondent number 4.
Okay. And who's the petitioner?
For the petitioner.
Learned counsel for the petitioner, Mr. is present. Learned senior counsel, Mr. Sidi Jamir, appearing for respondent number 4. Prays for 3 weeks' time to file the affidavit in opposition. A similar prayer is made by the counsel for respondent number 5, Ms. Such and such. So, what about the government filed?
My Lord, here I'm yet to receive instruction. However, under CPC Order 1, Rule 10, whether I may be completed as a
Getting advice from the court.
You are not a party now.
I'm the party, but since the dispute is between the private parties,
That may be raised at the time of hearing.
Yes. We'll just say learned counsel, learned additional agent, Mr. L.T. Sanctum is present for the state respondents. Okay. List 1 and 2.
1, 2, and 3.
1, 2, and 3. List.
Ladyship, I'm for respondent number 6.
Okay, Mr. Ali Bausakum prepares for respondent number 6. You'll also file. your
Yes, I'll
affidavit?
file.
Okay. So list after the winter vacation to enable the parties to file their pleadings. Yes, stop. List
Your
after the
Lordship,
vacation.
there is an interim.
The interim order passed earlier shall continue till the next date.
May I please, Your Lordship? Lordship, I beg to mention item number 8, behalf of S. Sham. Here she is yet to receive instruction, so kindly grant 3 weeks of time to file affidavit.
Government advocate, Mr. Attorney Sanctum prays for 3 weeks' time to file the affidavit on behalf of Miss S. Chang.
Lordship.
S. Chang, Learned Government Advocate. So, Learned Counsel for the petitioner, Miss Such is present, and has no objections. List after 3 weeks. Yes.
Ali oblige.
May I, Mr. Lordship, I beg to mention item number 13.
13.
Yes, Your Lordship. Your Lordship, we have already taken steps upon respondent 1, 2, 3 through register 80. So I beg the matter be listed after 2 weeks.
Learned Counsel for the petitioner, Ms. Such and such, submits that the notice on respondents number 1,
2,
1,
2, 3.
2, and 3 has already been taken through registered post, and therefore prays the matter may be listed after 3 weeks. List after 3 weeks.
Much obliged, Your Lordship.
For motion from the supplementary cause list, item number 16.
May it please Your Lordship. This appeal is directed against a judgment passed by the learned session judge Kohima, wherein the accused has been charged with the offense of rape, but the learned trial court disbelieved the allegation laid by the victim, but convicted the accused under section 354 of the IPC for outraging of modesty of women. Now, in the judgment, in the impugned judgment, if Your Lordship may kindly comment. Page 23 of the appeal memo.
93.
Yes, page 23.
Yes.
In this case, the evidence of the prosecutrix, her sister-in-law, that is PW4, the medical doctor, and the seizure witness. These are the only relevant evidence as far as this appeal is concerned. So allow me to just take a lordship to the findings of the learned trial court. At 14, the learned trial court here in this paragraph recorded the statement of the victim in this manner. Having examined the meaning of rape, I shall now appreciate the evidence brought on record by the prosecution. As seen above, victim is known to the accused and she treats him like her adopted father. The victim in her evidence has testified that on the night of incident, the accused came at around midnight asking to open the door. According to her evidence, the accused came and shouted at her for marrying a Bihari man. The victim also says that accused had asked for whiskey or rum and she handed a quarter bottle of rum and he sat down in the kitchen and started to drink. She further says that he started to beat her with a broom and also lifted the machete, threatening to cut her nose and leg, and in the scuffle he cut off her left hand side of her palm. Thereafter he cut the string of her salwar pant and raped her. Paragraph 15. Now according to the evidence of Pormila, now this is PW4, the sister-in-law of the victim who was in the same house at the point of the alleged incident. According to the evidence of Pormila, she stated that she was in the house when an unknown person came and knocked at the door and the victim opened the door. The accused flashed the torch and went to the kitchen and had liquor and asked the victim to make fry egg for him and was shouting bad words, and she heard the victim requesting the accused to leave and thereafter he left. She said that he called her uncle and mother and informed them about the accused creating problem in the house. However, this is the relevant part. However, she in her cross-examination stated that she did not hear any screaming, shouting or crying, except that the victim was requesting the accused to leave. This witness admitted that except for the verbal arguments, she has not heard or seen rape being committed upon the victim by the accused, nor did the victim said that the accused raped her. She also does not say, this is also important, Lordship, she also does not say that the victim narrated or disclosed anything against the accused. Now, this was after the incident. Strangely, notice the finding which has caused serious prejudice to the accused. Strangely, this witness was not declared hostile by the public prosecutor for not supporting the prosecution case of rape. Be that as it may, from the evidence of Pormila, who was in the house when the accused came, her statement could not establish any physical contact whatsoever between the accused and victim. The prosecution, therefore, does not get any help from this key witness. Now, there's a material contradiction between the evidence given by her sister-in-law and the victim. In fact, the victim, in her statement before the court, she said that she cried and shouted for help. Whereas, on the other hand, her sister-in-law, who was in the next room only, she only heard the victim quarreling with the accused person and asking her to leave. That was what she stated in the cross-examination. Now, in the findings of the learned trial court to the effect that this witness, that is the sister-in-law, was not declared hostile by the public prosecutor, was completely uncalled for. This was a statement given by her before the court. Now, at paragraph 16 is the medical doctor's evidence. Dr. Azo had medically examined the victim on the following day of incident. According to him, the hymen of victim was torn, and he also says that rage was distinct. He then further says that although possibility of rape cannot be ruled out, still, he cannot say that rape was committed on the victim. In the cross-examination, Dr. Azo said that he conducted the medical examination after a lapse of 90 minutes of the incident, and at that time, her private parts were washed, but however, he cannot say that there was recent sexual penetration on the private parts of the victim. Here, the statement of the accused before the police. Again, see, completely relying on inadmissible evidence. Here, the statement of the accused before the police, wherein he admitted to have touched the breast of the victim, but denied any act of sexual intercourse, is the material circumstances. Based on this, I've been prejudiced. This version stands corroborated, again, comparing my statement before the police, completely inadmissible with the medical doctor's evidence. This version stands corroborated by the medical evidence, as the doctor had deposed that there were no signs suggestive of recent sexual intercourse, though injuries and tenderness were found on the breast of the victim. He stood by his medical report. The evidence of doctor read together with the accused's own admission, that is the admission before the police, not before the magistrate, rules out the commission of rape as defined under section 375 IPC. Prosecution has failed to get any help from the doctor to prove its case against the accused on rape. Now, Lordship may come at page 27, paragraph 18. Now, I'll be reading from the middle part, the evidence of the seizure witness, PW8, starting from PW8. Lordship found it?
Yes, para 18.
Yes, para 18. PW8, is seizure witnessed, but her statement holds no weight as the seized machete, long pant, and quota belonging to victim, though has been seized in her presence, had not been sent to FSL for proof. The evidence of the above PWs are of no relevance as they have neither said anything in favor of the prosecution nor against the accused. Now, at 19, even the IO, the statement of the IO, Levinio, who investigated the case, admits in her cross-examination that the seized items, the machete, one long pant, and one kuti, were not sent for FSL test or for expert opinion. Now, in the absence of sending the seized material to the FSL, there is no proof that the machete was even involved. Now, Lordship may come to page 29. This was how the learned trial court dealt with the evidence, even though paragraph 23. I have already dealt with the evidence of victim and Pormila in the foregoing paragraphs of this judgment. It is true that victim has stood by her statement, but Pormila, key witness who was in the house with victim on the night when the accused came, has deposed that she has not seen or heard that rape was committed upon the victim. However, she in her cross-examinations, she stated that she heard the victim requesting the accused to leave her alone and that there were verbal arguments between them. She said that after the accused left, she found the victim shivering and crying. Dr. Azo has testified that there were scratch marks on her left breast and small bruise just above her right breast and also injuries at several parts on her body. Now, in this aspect, there is no evidence to show that these injuries on the breast were committed by the accused. Absolutely no evidence. He also stated that there was an injury on her left arm. The Lordship may note this. He also stated there was an injury on her left arm, which was a minor linear laceration measuring 2 to 3 centimeters. This statement of the doctor corroborates with the statement of the victim, as discussed earlier, that her left hand side of her palm. The victim says that it was her palm. Now the doctor says the left arm. Now the nature and the location of the injury is completely contradictory. But this was how the learned trial court delivered its finding, with the statement of the victim, as discussed earlier, that her left-hand side of her palm got injured. Now, the medical evidence does not disclose anything to the effect that there was any injury on her palm, or be it the palm or the fingers, while snatching the machete. Again, when the machete was not even sent for FSL to prove that this weapon was used in the alleged incident, how can the trial court rely on the usage of this machete? According to the evidence of the victim, she struggled from the clutches of the accused. Now, again, the victim says that she shouted and cried for help, when, on the other hand, just a few feet away, her sister-in-law deposed that she heard no cries, no struggle, or no shouting, except that there was some kind of verbal altercation between the accused and the victim, and she also heard that the victim was requesting the accused to leave. Now, if she could have heard all this, how can she not hear the cries or the shouts or the manner in which she was trying to struggle with the accused person? Now, therefore, in the absence of any intention or knowledge being established under 354, the trial court could not have, based on this evidence, convicted the accused under 354 the IPC. There are material contradictions. The statement of the accused before the police has been wrongly used by the trial court to corroborate the so-called medical evidence. There was no evidence to show that the machete was used, even a machete was used. The injuries have not been proved to have been caused by the accused also. Now, in view of this, I've taken the grounds which are appearing in the appeal memo, and I pray that the appeal may be admitted and notice may be issued.
Counsel for the appellant, Mr. Niralu. Mr. Tibapong, non-BP, appearing for the state of Nagaland. This is an appeal under section 415, clause 2 of the BNSS against the judgment dated 3/11/2025, passed by the learned principal session judge Kohima, Nagaland, in GR case number 112/2018, arising out of Kohima Women PS case number 0017/2018 under section 376 clause 1 of the IPC, convicting the accused person under section 354 IPC and sentencing him to undergo rigorous imprisonment for 1 year, along with fine of rupees 10,000. The appeal is admitted. Issue notice returnable within 4 weeks. Stop. No formal notice is called for as the state respondent is represented by the learned PP. However, the learned counsel for the petitioner shall supply extra copy of the appeal memo on the learned PP during the course of the day. Stop. Call for the trial court records from the Court of Session Judge, Principal District and Session Judge Kohima. List after 1 month.
Your Lordship, since it is the settled position that if an accused is convicted for a fixed or a short term, then the normal rule is to suspend the sentence and to release the accused on bail. I have also filed the application.
filed IA?
Yes, I filed the IA for suspension and to release the accused on bail. Now, the accused was on bail throughout investigation and trial. He has not misused his liberty.
He's on bail.
Yes, he was on bail, and now he's lodged in the jail. But
Then let him remain on bail because it's only
Yes.
a 1-year sentence.
yes,
And if this case is delayed, then it will
Very
become
true.
infructuous.
I'll leave it to your lordship.
Yeah. Okay. This application under section 430, clause 1 of the BNSS has been filed, praying for suspension of the sentence in GR case number 112 of 2018 and judgment dated 3/11/2025, sentencing the accused applicant to rigorous imprisonment for 1 year and a fine of rupees 10,000. Stop. Learned counsel for the applicant / appellant, Mr. Eli Ralu, as well as the learned EP, Mr. Tipapong, for the state respondent. Stop. The learned counsel for the applicant submits that the present application under Section 430, Clause 1 of the BNSS has been filed accompanying the criminal appeal under Section 415, Clause 2 BNSS, which has been filed before this court challenging the conviction and sentence. So, it is stated that the said connected appeal raises substantial questions of law and fact, and there is and the appellant has a good case and has every chance of succeeding in the appeal. So, it is also submitted that the appellant was on bail throughout the investigation and trial and has never misused the liberty granted to him, nor has he attempted to abscond or influence the witnesses. Stop. What is this? A hospital? He is now admitted in
yes, he was admitted after he presented himself before the jail authorities on 3rd November. At night, he was again admitted into the hospital. Till the date of filing the application, he's still in the hospital, now the hospital authority.
It is also stated that the appellant presented himself before the jail authorities on 3/11/2025. Stop. However, due to some emergency medical complications, he was admitted at Naga Hospital, Kohima, UTP cell on 3/11/2025 at around 8 p.m. Until the time of filing the present application, the accused is still admitted in the hospital. Stop. It is therefore prayed that the execution of the sentence awarded to the appellant applicant by the learned session judge Kohima in GR case number 112 of 2018 may be suspended pending final disposal of the connected appeal, and it is also prayed that the appellant may be released on bail on such terms and conditions as this court may deem fit. So, the court has considered the prayer made in the application, and these are the view that the sentence be suspended in the interest of justice. So accordingly, the judgment and sentence dated 3/11/2025 in GR case number 112 of 2018 is suspended till the disposal of the present of the connected appeal. Connected appeal number 4 of 2025. Stop. Para. The accused, the convict slash applicant is also allowed to go on bail. I think the earlier terms and conditions
Very well.
yes.
I'm ready to comply with any of the
Yes.
terms and conditions.
Is allowed to go on bail on the terms and conditions. Do you have the date of the bail order? The earlier bail?
My apologies, I don't have that.
Okay, anyway, on the same terms and conditions as allowed in the regular bail which was granted to the applicant by the learned sessions court. On the subject to the additional condition that the applicant slash appellant shall leave the jurisdiction of the trial court without permission. Yes.
I'm deeply obliged.
Much obliged.
For admission, item number 2 and 3.
May I please, Lordship? Here, the leading counsel is supposed to appear, but there's some technical failure from his side.
Yes, what is this for today? Why has it come up? CGC, are you filing any objection?
Yes, my lord.
You're going to file?
I
You have filed?
yes. My lord, the plating is completed.
Readings complete?
Yes.
Then can we hear today?
Am I audible?
Yes?
Am I audible?
Yes, yes.
Yes. Lordship, I earlier order dated 21/11/2025. This honorable court was pleased to hold at paragraph number 5. I may be allowed. The above being said, it is the settled law that
21/11.
yes, last order. That's the last order.
Okay, okay, yes.
Paragraph 5.
Yes.
The above being said, it is the settled law that courts cannot substitute its views in a matter of gradings given in a person's SAR apart. In this respect, the judgment of the Rajasthan High Court may be considered in the case of Vinod Kumar Agarwal versus High Court of Judicature for Rajasthan. So, Lordship, in this regard, Lordship, I rely on another edition of the Honorable High Court of Rajasthan, Lordship, that is 2020-23 SSC Online Raj 128.
Yes.
Lordship, paragraph number 7.
Have you supplied the judgment?
Lordship, I have my colleague, I think he has step.
What do you want to show from that?
Lordship, it is, I want to say that, Lordship, it is, I'm just read the relevant part, Lordship, at paragraph number 7. It is saying that at the outset, it is made clear that this court cannot moderate the appraisal and grading given to an officer employee. While exercising power of judicial review, court should not venture to assess and appraise on the grading of an employee. But if the court finds that adverse entries made in the SCR or grading given to an employee are vitiated by extraneous consideration, the court must interfere and quash them. This is my view.
So only if there is extraneous consideration.
Yes, Lordship.
Otherwise, the court cannot interfere.
Lordship, and the same is there in my case. And the same decision, Lordship, is the relevant paragraph is at page. Is at page paragraph 7 to 15, Lordship.
Paragraph
7 to 15.
of the
Paragraph
judgment,
7.
of the
Yes,
judgment.
yes.
Wait. This is a judgment of the Rajasthan High Court.
Lordship, yes, Lordship.
Yes. Whereas this Vinod Kumar Garwal is a Supreme Court judgment.
No, no, Lordship. It is also Rajasthan High Court.
It's a Rajasthan High Court judgment.
Lordship, Lordship.
Okay, so basically, what are you challenging in this petition? In your
Lordship, by this petition, Lordship, I'm challenging two aspects, Lordship. That is the speaking order passed by the respondent number, that's annexure B, page 89. Here, Lordship, I'm just briefly sub. It happened, Lordship, after receiving
page
the
89.
Lordship. Page 89, and the type copy is at page 90.
So you had approached the court earlier.
Lordship, this is the second round of.
Okay, so in the first writ petition, what did the court say?
Lordship, when I received the SCR and the copy of the SCR and the FR, I filed representations. Then this honorable the court was pleased to direct the respondent authorities to consider my representation. Thereafter, while considering my representation, they passed this impugn speaking order.
So by the impugn speaking order, they did not interfere with the earlier
Lordship, yes.
remarks. Okay, so from this, how do we know that, how does the court know that there were extraneous considerations while passing this order?
Now, Lordship, I have to go to the facts of the case, Lordship. The facts of the case.
Acha, learned counsel, can you appear in person on another day?
Lordship, I will try, Lordship.
Because the audio is not very clear.
So in that case, Lordship, let this matter come up for hearing, Lordship, when the pleadings are complete.
When? Next week?
Lordship, let this matter come.
Learned counsel for the
After
petition.
2 weeks, Lordship.
Mr. B. Deb. Mr. B. Deb is present. Stop. Learned CJC, Mr. Z.M. Muli is present. It is submitted that the pleadings are complete in this matter, and therefore let the matter be listed for hearing. When?
After 2 weeks, Lordship.
After 3 weeks.
2.
this is the matter for hearing after 3 weeks. Do you want a fixed date? You want a fixed date?
It's possible, Lordship, it's possible.
This on, it'll have to be after the vacation.
After vacation.
Yes. 19, 20, any date? 20th of January.
I do.
20.
For admission, item number 4.
Straight के लिए दे दो yes
Milad.
My Ladyship, these are the judgments which we are relying upon. I'll briefly, My Ladyship, go through the contents, and then, My Ladyship, I'll show the documents on record. My Ladyship, the petitioner has approached this Honorable Court
what is this quashing petition?
Yes, My Ladyship. For questioning of the proceedings against him, as well as the FIR number 274 of 2023, registered at East Police Station, Dimapur, Nagaland, under section 420, 406, 403, and 120B.
Let's see the FIR first.
My Ladyship. My Ladyship, it's on page number 26 of my petition. Before I start with reading the FIR, My Ladyship, I would like to highlight that the FIR has not been, the complaint or the FIR has not been informed by the victim. Some third person has informed the police, and on the basis of some third person, the said FIR has been registered. It is under in violation with section 2AA, My Ladyship. It categorically says that only victim is identified as only either the victim herself or himself, or through her legal heirs, or through guardian. My Ladyship, some third person who is unknown has given this complaint and therefore was registered. He is not party to any documentation which has been made on record. Per se, My Ladyship, he has not been known to the present petitioner. As well, My Ladyship, the victim in this case has also been not known to the petitioner. In the FIR also, the petitioner has not been named. My Ladyship.
This Kruto Tetsuo is not the victim.
Not the victim, My Ladyship. He is some third person. In the complaint itself, the Mr. Kruto says that Srimati Asengla Ao, who is resident of Nagaland and has been a known person and close associate to him. That is just the averment which he has given in complaint. Not a legal heir, not a guardian. It is again, it is, My Ladyship, in violation with 2AA of section 2AA CRPC, My Ladyship.
Okay, then.
Yeah. Then upon his complaint, My Ladyship, in this complaint, he says that accused number 1 has introduced accused number 2 to the victim of this case, and that, My Ladyship, I'm on first para, line 4. That Timothy Joshua again introduced Rakesh Singh, accused number 3, and allegedly to be farmer from Kolkata, to the victim. Subsequently, Sri Mahesh Avasthi, alleged managing director of RM Trading Association, was also introduced with Timothy Joshua to the victim. That after that, My Ladyship,
Petitioner here is Anup Gadal.
My Ladyship, yes, and petitioner is Anup Gadal. That accused number 3, who alleged to be a farmer from Kolkata, has alleged to find the article analysis to be of a mystery machine. My Lordship, it's a very, he says that she is a lady who is well known, well respectable, and a lady which we later came to know that she's a class 1 gazetted officer, has been cheated by these persons on a mystery machine. On the description of the mystery machine has been given, my Lordship, on page 2 of the complaint, and that itself is a bogus a verment or assessment. It does not say about what machine, what kind of thing, just it says the size of box, thickness, type of glue, tolerance, radiation, voltage, heat. What is this machine has not been even described in the complaint and has not ever been asserted in the lower court, my Lordship, the court below. Upon delivery of this mystery machine, my Lordship, it has been stated in the complaint that she has handed over 4 crore rupees. A government officer has handed over 4 crore rupees for the mystery machine. And in return, they have stated her that they will return 22,004 crore rupees. My Lordship, I am in my career, in very first time I am seeing such thing, that a thing which has never been existed, a thing which has not been named, which has not been described, which has not been shown, and someone is paying 4 crore rupees, that too through various bank transfers to various persons, and then coming up and saying that I have been cheated. That too, my Lordship, with the various other persons, not naming the petitioner. Then some bank details has been given, my Lordship. In this, bank transfers from serial number 1 to serial number 22 has been given, and which is amounting to, my Lordship, 1,10,000, 20,000. Yes. 1,20,000, then 2,000, then 40,000, something like that till 22. Most peculiar are transactions are, my Lordship, transaction on serial number 13 and 14, which says 50 lakhs each. On 2 dates, 7/12/2020, then 7/7/2020. Then, my Lordship, on last 2 entries, that is 23 and 24, it says 45 lakh was given, 48 lakhs was given. How it was given, when it was given, has not been shown. And to whom it was given, my Lordship, it has also not been shown. All the chart itself in the complaint on para number 2 and para number 3, it has not been shown that who has been the beneficiary of these transactions. Then, my Lordship, the complaint says that a transaction of 23 and 24 is yet to be found out that to whom the payment was ever made. Then, my Lordship, on para 4, it gives the details of the accused persons, and these are as follows, my Lordship. First is Naro, accused number 1. Second is Timothy Joshua, accused number 2. Third is Manish Avasthi, accused number 4. Fourth is Rakesh Singh, accused number 3. I think mistakenly they have misnumbered it. Typographical error might have been happened. So, and now then it says that I have reason to believe an apprehension that they have cheated me. So kindly register the FIR. And on this complaint, the FIR was registered, my Lordship.
You are not named in this one.
Not named in the FIR. Then, my Lordship, if my Lordship has the trial court record, I'll highlight 3 orders in trial court record.
You have annexed in your petition.
We have annexed. Page number 36, my Lordship. 34, 35, 36. No, 36. In 36.
Page 36.
Page 36, annexure P4. Before that, my Lordship, accused number 2, he was arrested on 4th of December 2023. Against whom? Accused number 2. Timothy Joshua.
Arrested on?
Arrested, my Lordship, on 4/12/2023. No. 29/11/2023, my Lordship. In this also, my Lordship, police has moved to the Honorable Trial Court for issuance of NBW, but that has been categorically been rejected, that nothing has been suggested and no 41A notice in compliance with Arnesh Kumar has been given to the accused number 2. That is, that order has been annexed as annexure P2 at page number 30. of my petition itself, my lordship. Only one para is there. My lordship, last, third para.
Before the concluding para.
Okay.
Huh. Then this order was made on 14th 11/23, and then again he was, my lordship, arrested on the very next week and produced before the court. Nothing has come up, my lordship, that how 41A notice was not complied or police has given notice. Simply he was arrested, then he was taken before the trial court, and then he was given police custody, my lordship. Nothing, in violation with the previous order itself, learned magistrate has granted police custody, not even going into the averments of the FIR or the same order which the same magistrate has passed, my lordship, in a very previous week. After that, my lordship, annexure P4, which becomes very relevant,
Yes.
on page number 36.
This is bail order.
It is bail order, my lordship. It says that 60 days has passed, police has not filed the charge sheet, therefore he has been given bail. My lordship, because no case was existing, it was, even if we go through the alleged complaint, it was purely a monetary dispute among these parties or parties unknown. So 167 has not been satisfied, therefore he has been granted bail. Because, my lordship,
We got default bail.
default bail, because there was nothing against any of these persons. And this arrest was made just as per abuse of law, against the law, and just to extort money from the persons who has been named in the complaint.
Then after that, how do you come in?
Next order, my lordship, next order I'll highlight. On the very next date, what happens that they approach, annexure P5, page number 38. They approach to the learned trial court, stating that issue arrest warrant against the present petitioner. They had full 60 days chance to file a charge sheet, show the transactions, who all were the beneficiaries, how this cheating has happened, how criminal misappropriation of property has happened. They didn't show anything, they didn't file any charge sheet, they didn't do anything at all. For 60 days they waited, default bail, when the default bail was granted, they moved to the learned trial court for issuance of arrest warrant against the present petitioner. Nothing has been shown in that application as well, my lordship, how his name has come up, which has been categorically rejected again by the learned trial court. Third para, my lordship. I have gone through the application. I have also heard the IO of the case. It appears that no notice has been issued to the aforementioned Anup Gadal, which is petitioner in this case, prior to this application being moved for issuance of non-bailable warrant. Under these circumstances, this honorable court is disinclined to allow the prayer.
This is order dated?
Order dated, my lordship, 31/2024, 30th January.
Okay.
Then, my lordship, then comes, after 10 days, they went to his house, Anup Gadal, in violation with the order of this honorable court. No notice has been served, nothing has been given to him, even no averment has been made against him. Just because he was known to the accused who has been granted default bail, they went to his home, searched his home like anything, ransacked his entire home. Whatever amount was there in cash, they have recovered. Then, my lordship, he along with his wife and his brother-in-law were taken to Dimapur, brought to Dimapur. My lordship, in this order, when they have produced, page 39, when he was, after arrest, he was produced before the learned court. In this, my lordship, a very peculiar fact has arisen, that when he was brought to Dimapur, he was not taken to court. In this order also, it has been recorded that he was presented through VC. And his wife as well as his brother-in-law, they were also kept in police station, but neither made party, nor they were produced before court. Only the petitioner was produced before court through VC. His ground of arrest was not given in writing, my lordship. His ground of arrest was not even known to him. They were only informed that there were some money transactions and this person was involved, and since you are known to him, we have seen some transactions against him, then only we are taking you to Dimapur. He was never taken to court, my lordship. I'll highlight the relevant para. Also, my lordship,
No, this 10 to 24 order,
my lordship.
it is passed in his presence, isn't it?
My Lordship, it was passed through VC. My Lordship, I'll highlight. Presence of a third line, my Lordship. Presence of accused person is secured through video call. Not even VC, through video call. He wanted to inform the learned magistrate. He was not given a chance. Even, my Lordship, for 3 days they kept his wife, his brother-in-law.
Just see after below that, accused person states that he is aware of the grounds of his arrest.
My Lordship, because he was on video call, he was not produced in court. This is, a performa order, which we just change the name and pass such orders. In this order itself, I'll highlight the same trial court which has declined arrest warrant on a week prior, has not said why he has been arrested, what is his grounds of arrest, and it just says that he is needed in investigation. An investigation of what, my Lordship? It's a monetary dispute. Even if we accept that it was a monetary dispute, it's a very civil nature. How can he be granted police custody, or how can he be arrested for a monetary dispute which he has not been named in the FIR itself? No circumstances leading to his arrest has been recorded in this order. I'll just read the relevant para, second last para, third last para, my Lordship. I have perused the relevant material on record, and it is seen that sufficient ground exists warranting arrest of accused person. What sufficient ground has not been said, has not been disclosed, because the same court in a previous week has refused. But now the court is saying that sufficient ground is existing. That means the learned court is again going against her own order. It is also seen that the arrest of accused person is necessitated in the interest of investigation. My Lordship, even he has not been issued any notice. A clear violation of Arnesh Kumar was there, which the learned court itself has taken on record. But now how it has become relevant for investigation has not been recorded in the present order. It's a performa order, my Lordship. It has been passed in contrast with the previous order passed by the learned court itself. Then, my Lordship, on the very next date, what happens that he was asked to repay some money. Since he's a film producer, my Lordship, he has some leverage of money. His wife, his brother-in-law were also part of family business, and they were made present in the police station. They were not allowed to leave the police station. Neither they were arrested, nor they were produced before the court. So on 12th, my Lordship, they have been coerced to pay
So on 10/2/24, you
my
were
Lordship,
given custody.
given 7 days police custody. 7-day police custody was granted.
Then what is this agreement?
During that period, my lord, when he was in police custody, on 12th, so now police has started making pressure to him, and on 12th, my Lordship, since his wife and brother-in-law was with him, he was asked, they were asked to inform their family members for returning the money to some unknown persons. My Lordship, these are the bank receipts. His relatives has forced to pay the amount. If you see, my Lordship, the money to whom it was given, it was a gas agency. It was a third party, some Vika Awami, who is fourth party, who is not even part of the alleged transaction. So these 3 payments were made on 12th. Then, my Lordship, from 13th, what they did in police custody itself. Yes. While he was in police custody on 13th, using his own mobile phone, my Lordship, whatever amount he and his wife had in account, they were transferred during night, my Lordship. 3 transactions were made through their family members in Kalimpong, in their home district. These are the bank receipts, and then online transactions were made during the night while he was in police custody using his own mobile phone and his wife's mobile phone, which was also present in police custody with him. Then, my Lordship, on the very next day, alleged agreement was forced into. While he was in police custody, my Lordship, I'll highlight the agreement. Annexure P7 on page number 41. So these are the transactions while he was in police custody using his mobile phone. The online transactions were made on various other account numbers who are not party to these transactions. So the police officials have been hand in glove with the complainant and with the alleged victim, my ladyship. I do not consider her victim because in present court also, my ladyship, they are playing fraud with this court also. On the very next day when the application was filed, on 7/8/25, on the very next day, in your order itself it is recorded that someone has appeared on their behalf, said that we will file wakalat, we will file our reply. But neither they have filed any wakalat, no reply till date has been filed. Because, my ladyship, no person of this name exists. The complainant as well as the victim, alleged victim, they have some business with some of his known persons, and now since they have forced him to pay, they are hiding behind the bushes and they are not coming forward. Even they are not filing their wakalat, nor filing their replies, neither in the trial court nor in this court itself, my ladyship. The victim herself has never turned up in trial court, has never turned before the police. Mr. Kruto, who is the complainant, has never turned up in trial court, never turned up before police. Some 8-9 persons.
7/8/25.
Yes, my ladyship, yes. And after that, after 2 dates they were asking.
This year, you're appearing, isn't it?
Yes,
For R3.
R3. Not filed wakalat. So how can we say that he's here, my ladyship? If wakalat is not on record, no power of attorney he has.
Filed.
Yes.
It is not on record. We were informed in morning that it is not on record. No reply has been filed, no wakalat has been filed.
No, reply, the liberty is with the R3 whether to file a reply.
No, but this is my argument. This is my argument.
Reply is up to them, but then
This is my argument, my ladyship. It is up to them. Wakalat, because we were informed that wakalat is not on record. That's why I am making this submission.
It's on 7/8/25.
Wakalat Nama is not here.
Wakalat nama is not on record.
He sought time to file the wakalat nama.
7/8, he sought time to file wakalat, but he has never filed wakalat.
Is it in the second copy?
Lordship,
Just
yeah.
see. Wakalat Nama for R3 people. Okay, anyway, you continue.
Then, my ladyship, it is not on record. Then page number 41, my ladyship. While he was still in custody, 2 days after his mobile phone was used to transfer all this money, and his family members were forced to pay the money to some unknown persons. This agreement was made while he was in police custody. My ladyship, this shows that how much involvement of police was there to extort money. The state machinery was against the petitioner and how they forced. My ladyship, even we can see that notary has also happened. When he was in police custody, how come he signed the agreement? How come he be made sign before the notary? It says, notary also says on the last page, both parties have signed this compromise deed in sound health, robust mind, and without any undue influence. While he was in police custody, how come this is possible, my ladyship? He was forced to also sign on checks, which his wife was asked to bring, which has been made, but they have not been honored. So we have just made part of our page 50, part of our record. At page 50 it is there. But these checks were never honored after that. My ladyship, so this alleged agreement was forced and through unknown parties, through unknown persons. My ladyship, in this, if you'll see, it says that Mr. Kruto has come up to sign this deed. Mr. Kruto has himself in the complaint has said that the victim has been cheated money, not him, and he is making this agreement, my ladyship. And he has received payment of rupees 1,24 lakh, page 2 of the agreement, 1,24 lakh 39,100 through multiple transactions. Also, they have forced him to sign checks, which I have shown on page 50, which is amounting to 34 lakh 39,100 rupees. However, this has not been honored, but the checks were in their custody and they are still lying in their custody. In this agreement, my ladyship, nothing has been mentioned that how he owes money and why he is making these payments. It is categorically I'll say that it is knowingly has been concealed. That never or at none of the paras says that how he is part of the transaction and how he is forced to pay the money while he is in police custody, my lordship.
Nowhere in the agreement mentioned about the name of
About the name of the alleged victim.
And who are these Anupama and Nawang?
Anupama is wife and Nawang Chemi Bhutia is his brother-in-law. Both were present, my lordship, in police station. They were not allowed to leave Dimapur police station for 5 days. When this agreement, alleged agreement, was given to them, then only the wife of the petitioner as well as the brother-in-law of the petitioner was allowed to go out of the police station. Then, my lordship, very important averment from the trial court itself. This is on Annexure P8, the bail order. Bail order, my lordship. Annexure P8, I'll highlight just the relevant portion on page 46, second para. On going through the case diary, it appears that there is a prima facie material against the accused Anup Gadal for offense of cheating, just cheating, my lordship. However, I have also considered the nature of the offense where it is clearly seen that the present case arose out of monetary transaction by the informed accused persons. My lordship, it says monetary transaction. Can a monetary transaction be made part of a criminal offense and an FIR be registered for a monetary transaction? And that too, they are alleging that they have an agreement for the mystery machine. It itself says that there was a monetary transaction, which my client, which the present petitioner is not a party. Then it says, my lordship, this ground I have considered the deed of agreement executed between the parties where it is reflected that present deed has, the present has paid amount of present accused has paid amount of 90 lakhs. So the court also is recognizing this deed which has been signed, which has been signed while he was in police custody, while he was languishing in police custody. And the court itself is saying that it's a monetary dispute, my lordship. So my arguments now on this, my lordship, that since the court itself says that it's a civil dispute, it's a monetary dispute, the proceedings against the petitioner cannot sustain, my lordship. Number one. Number two, my lordship, the FIR which has been registered I have not been named. Number three, my lordship, nothing has come up on record against me prior to my arrest. Just to extort money, I have been arrested and then I have been forced to sign the agreement. Then my wife was forced to hand over the checks, which I have annexed at page 50. Then, my lordship, the civil nature of dispute, if any, among the accused persons who have been named on page number 4 of the complaint is prima facie if we take it for at par value. Then also I do not come into picture merely because I was knowing Mr. Joshua and merely because I had some transactions with Mr. Joshua. I do not fulfill the definition of forgery under 420, under 403 or 406. My lordship, I'll just read the provisions. 420, my lordship, it says, cheating and dishonestly inducing delivery of property. Whoever cheats and thereby dishonestly induces the person deceived to deliver any property to any person or to make, alter, destroy the whole or any part of the valuable security or anything.
You're reading from IPC?
IPC 420, my lordship. Oh.
IPC.
BNS, I think 317 is same. No, IPC. BNS 317 is same, my lordship. IPC is सबसे नीचे. Number 2, yes. If we take the...
What is the status of the case now before the trial court?
I have not been summoned after I have been granted bail.
Just charge sheet.
charge sheeted.
That we do not know, because 207 notice or 207 compliance has not been made. First time we have been knowing that we have been charge sheeted. We have not been informed either by police nor we have received summon the charge sheet, if the charge sheet has been filed. Sir, do you have copy of charge sheet? Can you please give us the copy?
Should I have this charge sheet come so that we have the whole?
Yes. Please, thank you. My Lordship, it is there, yeah. 420, my Lordship. It says, cheating and dishonestly inducing delivery of property. Whoever cheats.
1 minute.
Yeah.
Yes.
Whoever cheats and thereby dishonestly induces the person deliver any property to any person, or to make, alter or destroy the whole or any part of property, valuable security or anything which is signed, sealed and which is capable of being converted into a valuable security, shall be punished with imprisonment of either description for a term which may extend to 7 years. My Lordship, in the complaint itself, I have not been named, I have not been said that I have delivered something, or I have induced delivery, or I have benefited from something which has arisen between the petitioner as well as the victim or the complainant. So the definition itself does not satisfy. Also, my Lordship, even if we take the complaint at par, then also it merely discloses the offense in civil nature, monetary transactions. It cannot be made part of a criminal trial. An FIR or also a criminal proceeding cannot be initiated against the petitioner.
Then the other is 403, 406, 150. Okay.
My Lordship, my arrest was illegal. I have been taken from my home, but it was told that I was taken from Delo. It's an area in some resort in Delo. It's an area in Kalimpong district. It has been shown that I have been taken from Delo. My Lordship, grounds of arrest has not been given in writing. So even if the court records that ground of arrest is known, my Lordship, that is not being proved. I am just seeing the charge sheet. In this also grounds of arrest, copy of grounds of arrest has not been supplied to him. Nothing. Just the facts, just the story, narrations has been given that how it has come up. My Lordship, yes. And it is just the elaboration of the FIR. No direct transaction has happened between me and the alleged victim and the alleged complainant. I have been knowing to Timothy Joshua. He is a resident of my place. I have been long-term association with him, but that does not itself make me a fraudster, or I have not been named a fraudster, or I have not been named in the complaint as a cheater, as who has cheated. My Lordship, it is very categorically also states that a mystery box which was purchased, for which 4 crore rupees was paid, and in return 22,004 crore rupees will be repaid. My Lordship, this story itself is not digestible. A person, a victim who says that she is a respectable, well-known, well-educated person, later on we came to know that she is a class 1 officer. How come she is having 4 crore rupees and transferring to such persons without verifying, without noticing what is there, what the averments are, and how she will get 22,004 crore rupees just after paying 4 crore rupees. The complaint itself shows, my Lordship, it's a vitiated complaint. It has been filed to extort money. No direct relation has been shown against me. Yes. I have filed some judgments, my Lordship, today. On the list, my Lordship, on page, on last judgment, that is on 13th, my Lordship, I'll just tell the page number. Page number 223, my Lordship. The judgment started 223.
Yes.
Yes. Yes, and my leadership, it's a recent judgment. It ends at 249. So I'm on page 248, my leadership. Second last page, 248. My leadership. Second last page, yes. Para 56, my leadership. In conclusion, it is held that the constitutional mandate of informing the arrestee the ground of arrest is mandatory in all offences under all statute, including the offence under IPC, now BNS 2023. The ground of arrest must be communicated in writing to the arrestee in the language he understands. In case where the arresting officer or person is unable to communicate the ground of arrest in writing on or soon after arrest, it be so done orally, the said ground be communicated in writing within a reasonable time and in any case at least 2 hours prior to production of the arrestee. 4. In case of non-compliance of the above, the arrest and subsequent remand would be rendered illegal. My Ladyship, in the charge sheet, nothing has been given for ground of arrest. Just in order, it says that accused says that he is aware of his ground of arrest. It has to be given in writing, and not just in writing, it has to be given in the language he speaks. He is a Nepali speaking person. He is not a local from this place. So he's not. This arrest itself, my Ladyship, is in violation of the court order itself, which I have highlighted. A week prior, the court itself has stated that he cannot be arrested. 41A compliance has not been done. So it says that what happens when ground of arrest has not been given? The arrest becomes illegal. And my Ladyship, not just the arrest, the after effects of the arrest in the present case, every illegal or every possibility which can be or which could be for extorting money be employed by the law enforcing agency has been done against the my Ladyship, against the petitioner. My Ladyship, I'll highlight 2-3 judgments which I have given. My Ladyship, first judgment itself on page number, it's on para 11 of the first judgment which I have submitted in the court itself, my Ladyship. Para number 11.
The first judgment?
The first judgment, my Ladyship. It starts at page number 1, ends at 21. Around page 13 of the judgment.
Yes.
Yes. Para 11. Before averting to the facts of the present case, it is necessary to reciprocate that the settled legal principle governing the exercise of inherent power under section 482 CRPC. It is well established that though the High Court possesses wide and plenary inherent jurisdiction, such power is not unbridled or unlimited, but circumscribed by the self-imposed restraint evolved through judicial pronouncements. Then, my Lord, it discusses Bhajan Lal, in which it says that abuse of process of law is has to be. Yes. Then I'm not going to Bhajan Lal. Then, my Lordship, I'll highlight 2-3 more judgments and then I'll conclude. Para 16 itself, my Ladyship, in the present.
In the first judgment?
Yeah, in the first itself. Page 15 or 16, my Ladyship.
Yes.
Para 16, despite this background, the police proceeded to file a charge sheet dated so-and-so against the appellant for offence under 420, 467, 468. Even if the allegations are assumed to be true, they unmistakably arise of a commercial/contractual transaction relating to a loan and repayment, which has been given a criminal color. The case thus falls squarely within categories 1 to 7 of Bhajan Lal, namely where the allegations do not disclose the commission of an offence and where the proceedings are maliciously instituted with the ulterior motive. Continuation of such prosecution would amount to an abuse of process of law and consequently warrant questioning under 482 CRPC. My Ladyship, the process has been abused. He has been physically tortured. His wife, his brother-in-law has been mentally harassed to make payment, even though he was not named in the FIR. No circumstances have arisen. No circumstances of his arrest has been given in the order of his police custody. Then para 17, my Ladyship, it highlights the Indian Oil judgment, which I am not reading, my Ladyship. Para 19, my Lordship, I have also given this judgment in this. Para 19 says, most recently in Shailesh Kumar Singh versus State of UP, this court disapproved the practice of using criminal proceeding as a suitable for civil remedies, observing that money recovery cannot be enforced through criminal prosecution where the dispute is entirely civil. The court cautioned High Court not to direct settlement in such matter, but to apply the settled principle in Bhajanlal. So court below, my Lordship, has taken note that settlement has happened, but has failed to register that how settlement has happened. Para 20 of this judgment itself, my Lordship, applying the above principle to the fact of present case, it is manifest that the dispute concerning repayment of loan money and the alleged coercion in execution of document is purely in civil character. The essential ingredients of cheating or forgery are not prima facie made out. The institution of multiple FIR in quick succession, particularly after the appellant has already, this is relevant to that case. 21, my Lordship, the High Court in refusing to quash proceeding misdirected itself in law by failing to apply the ratio laid down in Bhajanlal, and subsequent authorities referred to above, which uniformly hold that the machinery of criminal law cannot be permitted to misuse for settling civil disputes. That is para 21, my Lordship. My Lordship, I'll once again highlight the judgment in Shailesh, which has been mentioned in this case.
No, there are many judgments.
There are many judgments
regarding
yes.
civil proceedings,
Civil proceedings.
being given a criminal color.
Yes.
But we have to look into the facts of each case.
Yes,
okay?
ma'am.
So the initial deception, whether there was an initial intention to deceive, deception, that is the criteria.
That is, my Lordship, if I have
So
not...
that I can only see from the charge sheet.
My Lordship, I'll just say that if there was initial deception, I was not named in FIR. There was no deception.
Maybe.
Yes. Also, my Lordship, just a second. Sir.
Six accused.
All six?
Yes, including the
Yes, including the present petition.
But after we file this petition before your Lordship court.
When the date says that when we have filed the present case here, then the machinery moved.
This is filed on, the charge sheet is filed on
28/6/2025. When after the application has been made and the notice has been given to them, advance notice has been given to them. So then they moved, my Lordship, because we are approaching this court. Also, my Lordship, we have been threatened.
No, but even if arrest is vitiated, the criminal proceedings is a different thing.
Different, my Lordship.
Yes, you may be even released on bail following that when arrest is illegal.
Yes.
But doesn't mean that the proceeding is quashed.
My Lordship, I'm just highlighting the
These
issues.
are two different things.
Yes. I'm just highlighting the illegal arrest and implication, my implication in the present case, how I have been implicated, based upon some transactions which I had with these accused persons, one of the accused person, that too in past. I have never been in picture. I have never met the alleged victim. I have never met the alleged complainant also. And since they are from my place, I have some business dealings with them because I'm a film producer, and this person is pastor and has been helping in his production and construction activities. So these business transactions in past.
Okay, now come to your judgments again.
My Lordship. Judgment number 3, at number 3, Shailesh, it's on para number 9. Para 9 of the judgment, my Lordship, it starts at page 35.
Para 9.
Yeah, para 9. What we have been able to understand is that there is an oral agreement between the parties. The respondent 4 might have parted with some money in accordance with the oral agreement, and it may be that the appellant owes particular amount to be paid to respondent. However, the question is whether prima facie any offence of cheating could be said to have been committed by the appellant. How many times the high courts are to be reminded that to constitute an offence of cheating, there has to be something more than prima facie on record to indicate that the intention of the accused was to cheat the complainant right from the inception. My Lordship, nothing is there that I was in picture right from inception. There was no intention of cheat. My Lordship, I was not even in picture from day 1 till last day of my arrest, till 30th when they have moved to court for issuance of arrest warrant against me. Because they could not extort money from the other person, Mr. Timothy, then only they have come to me. Because he was granted default bail, they could not extort money from him, then they came to me after going through his transactions. Otherwise, my Lordship, how come it is possible that someone who is arrested 2 months before an investigation qua that person has happened, and after 2 months, when he has been granted default bail, the authorities are awake and now they are going for the other persons. Generally, what happens in an investigation, when someone is arrested, they investigate him, then they start going behind the other culprits. Here they waited for 2 months. They didn't file any charge sheet. They didn't do any investigation. They just extracted how many persons can be made scapegoat, how many persons can be made party, so that the extortions can be made. Leaving behind the, my Lordship, the complaint. Because the complaint itself is very absurd in nature, my Lordship. Who can believe that after giving 4 crore rupees, someone will give them 22,000 4 crore rupees? This itself, my Lordship, shows that this is beyond, what can we say, beyond human intelligence. A lame person who is not knowing about any business or not knowing about the transaction cannot believe on these. Because for cheating, my Lordship, there has to be fraudulent mind, and there has to be something from the very first day. But on the contrary, I was not in picture till my arrest. In this, my Lordship, then para 11 I'll highlight. Para 11 says, the entire case is squarely covered by the recent pronouncement of this court in Delhi Race Club 1940 Limited versus State of UP. I have also annexed that case, my Lordship. In the said decision, the entire law as to what constitutes cheating, criminal breach of trust, respectively, has been explained. It appears that this very decision was relied upon by the learned counsel appearing for the petitioner before the High Court. However, instead of looking into the matter on its own merit, the High Court thought fit to direct the petitioner to go for mediation, and that too by making payment of 25 lakh rupees to respondent. We fail to understand why the High Court should undertake such exercise. The High Court may either allow the petition saying that no offence is disclosed, or may reject the petition saying that no case for questioning is made out. Why should the High Court make an attempt to help the complainant to recover the amount due and payable by the accused? It is for the civil court or commercial court, as the case may be, to look into the suit. No suit has been instituted against me, my Lordship, till date. If I have cheated or extorted money, if I have promised them for mystery machine, or if I have some contractual obligations, something they would have made against me by approaching the commercial court, but nothing, no notice has been given to me prior to this. Nothing, no legal notice for non-compliance, no legal notice for payment, no legal notice, or nothing, not a single email, not a single WhatsApp is also with me, my Lordship. Not a single communication has been, in this charge sheet also has been made part of, that how I came in between. Then para 12 it says, my Lordship, that the entire dispute between the parties is of a civil nature, and then it went on to quashing. So these are, my Lordship, the recent pronouncements. If ma'am permit, then I can read out, otherwise, my Lordship, these are all recent judgments. Basic principles are. Yes. My Lordship, I'll also highlight Paramjit Batra, which I have given in this. Paramjit Batra also says that from very inception there has to be reason to believe.
That's what I told you.
Yes.
From the inception, there has to be the intention to deceive.
There has no allegations against me in in the entire file. Whatever they have communicated till my arrest, nothing is against me. No reply has been filed, my Lordship. This is one such matter, because nothing has come up against me.
No, but the court has to go through the records, not the charge sheet.
Yes, my Lordship. The court has to go through the record.
Even if the respondents have not denied anything,
yes,
the court has to decide on the basis
of record. Yes. But record itself suggests that it was a monetary transaction.
We'll see.
The complaint itself suggests that it was a monetary transaction.
We'll see.
Yes, my Lordship.
Yes.
Much obliged.
Yes, PP. Anything?
Your Ladyship, the record has been called, so I'll be relying on the judge. this is a serious criminal conspiracy. Your ladyship will see what the investigation has revealed. And, starting from the ban transaction, if your ladyship will come to page 3 of the charge sheet. Last para. In this connection, one account number 92002006971464 of the Axis Bank was found during the money trail of accused Timothy Joshi's bank account. Hence, notice under Section 91 CRPC was submitted to Axis Bank, Dimapur, for fetching of the bank records of the particular account and close requisition under Section 91 CRPC to Axis Bank for obtaining bank details as Annex 9. Reports received from Axis Bank for the above-mentioned account number, and it belongs to one Anup Gadal, that is the present accused. And while going through the statement, huge transactions were found pertaining to this case, enclosed certified bank statement of Anup Gadal as Annex 9. Also, a relevant account number pertaining to this case was found, and further requisition under Section 91 CRPC was submitted to the Axis Bank Dimapur, enclosed under Section 91 CRPC to Axis Bank for obtaining bank details as Annex 10. Hence, report received from Axis Bank for Samuel Joshi, this is one of the co-accused account number, and while going through the statement, huge transactions were found pertaining to this case. Enclosed certified bank statement of Samuel Joshi. Also, a relevant bank account from Axis Bank belonging to one AK Packaging was used in this crime, and it was found that huge money transaction was made to the account of Anup Gadal. So now, your lordship will see that there is a criminal conspiracy amongst them. Coming to, I'll just point a relevant para to the last.
With regard to the
para.
present petitioner.
Yes. Later in the year 2020, last
para
para of the same page, that the page which I've been reading. Yes. Later in the year 2020, I was introduced to Asanla victim through Naro Jamia. Mrs. Asanla came to Siliguri with one of her school teachers, and we discussed about the school project. Then after the meeting, I called Anup Gadal and told him that Madam Asanla is in Siliguri at Hotel Diamond, Siliguri town, and I told Anup Gadal to come and meet her. Then the next day in the evening, I, along with Anup Gadal and Samuel Joshi, brother of accused Timothy Joshi, went to meet Madam Asanla at the hotel. At the hotel, Anup Gadal told Madam Asanla about a school project and told her to submit the school documents along with details of the measurements of the school. Anup Gadal further told Madam Asanla that the school fund is of rupees 50 crores and that she would arrange an amount of 50 lakhs to pursue the project. Anup Gadal also told Asanla that after she pays an amount of rupees 50 lakhs, they will give her the code number for withdrawal of the project amount of rupees 50 crore. Madam Asanla told Anup that she would think about the project and shall reply soon. Then the next day, Madam left for Dimapur. After Madam left to Dimapur, I contacted her repeatedly and requested her to do the proposed project. However, despite repeated calls, Madam Asanla did not accept it and declines to pursue the project. Since Madam did not accept the proposed project, Anup Gadal and I make a plan and come up with the idea of the antique box, mystery box. Then I told Madam that God has shown me a vision of an antique box, mystery box. I further told her that if she buy and acquire the box, she would be able to resell it to a reputed company with a huge profit. To make the deal more genuine, I also told her that I have already invested an amount of rupees 1 crore 50 lakhs and that she needs to pay an amount of rupees 50 lakhs to finalize the business deal. I also told her that I will donate the profit to the amount of rupees 50 lakhs to finalize the business deal. I also told her that I will donate the profit to the church and use the money for the good cause. After repeated discussion, Madam Asanla showed some interest. Before I induced Madam, Anup Gadal gave me some paper of RM Trading Company. Your Ladyship, here, RM Trading Company. This document is also a forged document. Ladyship will come to know from the statement of the accused, mentioning about the mystery box and details of the box, and eventually the story of fake mystery box started to materialize. The notarial certificate prepared was just a form of document proof in order to enable Madam Asantla to believe that everything is documented well. So the notary certificate was prepared by all of us, that is Timothy Joshi, Manish Awasthi, Samuel Joshi, and Anup Gadal. And it was all planned to take money from Madam Asantla. I knew that Madam Asantla was reluctant for some time, so I shared all the documents of the RM Trading Company through WhatsApp in order to make her believe that everything is genuine. I lied to Madam, and I myself had gone to the farm, which belonged to one Bangladeshi with the RM Trading Company, and during that time, a scientist also came to check the item mystery box. I also lied to Madam Asantla that some scientists also came all the way from USA to see the mystery box and certified the box and issued the genuineness certificate. And with the help of the company and the scientists, they together pack it so well that if we open it, it will blast out and it will become useless, as per narrated by me to Madam Asantla. After the company sell it with all their name, that is the RM Trading Association, the Bangladeshi people carried from Bangladesh border and brought it to Calcutta, which they had to rent a house and kept there for safety. And for that, we are paying 1 lakh rent for keeping there. And it was all just a fake story to deceive Madam Asantla. So after making her believe about the fake story and also introducing myself as a reverend pastor to Madam Asantla, she, without any hesitation, believed my deceiving story and agreed to invest. Madam also told me from the first day that she doesn't know anyone besides me. And Madam even told me that if she goes and deposits the money, I need to be there, and even with the company people. Then I fully assured Madam Asantla that this deal is genuine and it will work out successfully, and told her not to worry about it. Further, Madam told me that she is taking loan by mortgaging her house for the investigation, from the investment. So, Your Ladyship, this all reflects the deception, the intention of the
Ladyship,
petitioner.
See, I'll just clarify.
I may be allowed to conclude, then
just
get
one.
Later you can reply, no?
So, I'll just take a short time only. Then, to Your Ladyship.
Just the relevant
Yes,
portions regarding
statement
the
of the accused,
present
Anup Gadal.
accused.
Yes, page 11. Statement of accused Anup Gadal.
Yes.
I am a businessman and a contractor and also political party worker. I was baptized in the year 2014 under the ministership of Timothy's father, Sri Julius Joshi. Then after that, I was converted to Christian and followed my life righteously. Samuel Joshi is well known to me, who is a supplier of sand and chips for construction purpose and had been into touch with me for my construction work. In the year 2020, accused Timothy Joshi introduced me to Asantla at a hotel in Siliguri town. There, I, along with Timothy Joshi and Samuel Joshi, brother of accused Timothy Joshi, discussed about a school project and told her to submit the school document along with details of the measurements of the school. I lied to Madam Asantla that the school fund is of 50 crores and that she should arrange an amount of 50 lakhs to pursue the project. I also lied to Madam Asantla that after she pays an amount of 50 lakhs, they will give her the code number for withdrawal of the project amount of rupees 50 crore. Madam Asantla told me that she will think about the project and shall reply soon. Then the next day, Madam left for Dimapur. However, Madam Asantla did not accept the project proposal. Since Madam did not accept the proposed project, Timothy Joshi and I make a plan and come up with the idea of antique box. Since Timothy Joshi was a reverend pastor, I told him to convince Madam Asantla. As Madam Asantla showed some interest, I prepared and gave me some papers of RM Trading Company mentioning about the mysterious box and details of the box to Madam Asantla through Timothy Joshi, and eventually the story of fake mystery box started to materialize. That before the actual thing started in this cheating plan, I requested Manish Awasthi to perform the role of a managing director. So here it reflects the forged document, how they prepared the RM Trading Company, and Rakesh as a Bangladeshi farmer. Both readily accepted to join in this conspiracy. In this cheating conspiracy, besides I, Timothy Joshi, Manish Awasthi, Rakesh Kumar Singh, and Samuel Joshi. The other co-accused involved in Simon Joshi is Simon Joshi, brother-in-law of Samuel Joshi. As we have all benefited from the cheated amount, my role in this cheating conspiracy were booking of hotels, imitating as a co-investor, including Manish Awasthi and Rakesh Kumar Singh in the conspiracy, using my bank account for receiving certain portion of the amount from the victim and preparations of some false documents. On being asked, he stated that there was no such mystery box or antique box. In fact, it was just a conspiracy to extract money from the victim Asantla after their first plan to extract money from the victim through the fake school project, was rejected by the victim. So this is a clear admission of the accused. And your ladyship, from here we can see that there is a clear prima facie case against the accused. Now the findings of the investigation is that the last 22, page 22, based on the facts, reasons and materials evidence, a prima facie case under section 420, 403, 406, 120B IPC is found well established beyond any reasonable doubt against B, that is accused Anup Gadal, under section 420, 43, 46, 406, 120B IPC. So there is a clear prima facie case against the accused, and my prayer is that prosecution should be allowed to proceed. That's my humble opinion.
Yes, what did you want to say?
My leadership, I wanted to just ask that can a disclosure statement of a co-accused or can a disclosure statement of mine be used against me for making charge? Number one. Number two, she has not read the statement. Knowingly, she has not read the statement of the victim herself. It's on page 7 and page 8. Nowhere she has taken name of Anup Gadal that she has met Anup Gadal. How come a disclosure of Timothy or my disclosure, that is not my disclosure. I have been forced.
Other things are also there. CDR, bank account.
My leadership bank account and CDR, what they are saying, the transactions on page number 20 of the chart sheet, my leadership. Table 2, which says that I have received money. It says on 9/7/2020, then 15/9/2020, then 17. Let me read. Then 17/12. Then 17/12. Even if I am agreeing to this, I am not disputing this. Even if I am agreeing to this, 9/7/2020, 15/9/2020, 17/12/2020. My leadership, only 3 transactions. Not even a single transaction has been directly come up to me. The story which now they are trying to create, in this story itself, they are saying that 20 lakh was transferred from Shiv Shah to Anup Gadal. Who is this? He has not made in complaint or in the victim statement. He has not been named. Then 60 lakh was transferred from Shashikala to Amarnath Enterprise of an amount of 60 lakh. An amount of 44 was transferred to Amarnath Enterprise, and then from Amarnath to Anup Gadal. Madam, how come if you are receiving some money from third, fourth, fifth person, be made against me and can be used against me if I have not been named anywhere? Third transaction also. 50 lakh was transferred from Asangla to AK Packaging, and the same amount was transferred to AK to Anup Gadal. AK Packaging was by Timothy and them, and the victim has some dealings. And in my disclosure also, and in Timothy's disclosure also, he says that he helping in construction business, and in construction business, some transactions has happened. Just 3 transactions, my leadership. However, the victim says in the complaint that for 2 years he has made payments. Prior, subsequent, and then at later stage. None of the 3 stages I have ever been alleged in this chart sheet. Number 1, my leadership, 2 disclosure statement which she has read. Can she be used against me? Then they cannot. Laws are very clear about that. Number 2, my leadership, in the same chart sheet, I'm not saying that I'm not knowing Timothy. I'm saying that he's my pastor. I have converted to Christianity due to him, and I have some businesses beforehand with him. But that does not make me culprit in the present case. My leadership, page number 7. The statement of victim start and it ends at page number 8. Nowhere she has said that she has met Anup Gadal. number one. Number two, the entire story now which Timothy says, it comes, my ladyship, that a story starts from the school. That has not been mentioned in the FIR. That funding for school was asked, then 50 crore was asked for.
No, that came out during the investigation.
That came out, no, my ladyship, no, it says, the premises of the complaint says that how they met and how this mystery box has come
It
up.
mentions only about the
Yes,
mystery box.
about the mystery box.
But before that, many things happened.
Many things happened, but that has not come up in the statement of the victim, which is in the charge sheet itself. She has not named Anup Gadal even once. You can see, my ladyship, the details. If you want me to read, I'll read the entire statement. Nowhere Anup Gadal is named. Not a single document against me. Just because I had some dealings with Timothy Moleka does not make prima facie case against 420 Koa this complaint, my ladyship. And who can believe that mystery box, my ladyship, 4 crore rupees, if you pay 4 crore.
There are people who believe.
My ladyship, no. She is a government servant, class 1 servant, my ladyship. And how come a class 1 government servant is paying 4 crore rupees? That is also one question.
There are people who believe.
But my ladyship, she herself is not saying my name. Her statement, I am adopting her 161 statement, whatever she has said. Even if I am adopting entirely.
No, because she has not met you. She has met the other persons, not
No,
you.
but other person is saying na, that I have arranged meeting with Anup Gadal. She is not saying that I have met Anup Gadal. So his statement itself is contradictory. That police has written this story. My ladyship, what has happened, that as soon as we have initiated the proceedings here and filed the questioning petition, he has again got threat calls.
Okay.
And after that, this charge sheet was made. So this whole.
The court can only go by the report. So
Yes, my ladyship, in the present record itself,
statement also.
in the present record itself, my ladyship, the victim herself in her statement has not named Anup Gadal. No document has been filed by the prosecution stating that Anup Gadal was direct party. Anup Gadal has directly received any amount. Anup Gadal has directly handed over anything apart from a settlement agreement which was made when he was in police custody. Nothing, nowhere else his sign is there. No direct bank transaction, even with the alleged accused. During the entire period of 3 years, not a single transaction apart from these 3 transactions which have been come from via third parties. Which even if I accept it to be true, can this make a prima facie case against me, my ladyship? That too of cheating. If I was not involved, just 3 transactions have come up in my bank account, and I'm accepting that I had dealings with Timothy. He, in his disclosure itself, is saying that he was helping in the construction. This itself is, my ladyship, it has been extorted in hand and glove with the law enforcement agencies for extorting money. She says 4 crore was paid. And now in these 3 transactions, 4 crore, where is 4 crore, my ladyship?
So just come to this page 19. It was established that victim deposited an amount of 1 crore 14 lakhs into the bank account of Anup Gadal. So this, who are this Shoshang Shaw account and this Amarnath Enterprise?
Which page, Your Ladyship?
Page 19.
20, page 19 and 20.
19. Your Ladyship?
Just see this table showing the deposit of money in
20
the
lakh, 44 lakh and 50
petitioner's
lakhs.
account.
Enterprise to Anup Gadal.
Yes.
And how directly it is relevant?
This, because this 9720 was transferred from one Shoshang
Yes.
Shaw. Then this 15920 was transferred from one Amarnath Enterprise.
So these are the account number which are furnished by them to us, to the complainant.
No, but how I am directly involved?
What I want to know is, because it was not directly deposited by the victim into
Yes.
So how I am involved?
It came from some other source.
They
So
themselves have
this
said,
Shoshang
yes.
Shaw, then this Amarnath Enterprise, and this AK Packaging, is there any explanation in the charge sheet regarding this?
And how the amount has come also, my ladyship. Also, my ladyship, in the FIR, it says that the payment starts with 30th January 19. So there has been nothing in the earlier, even if I find this table against me, the complaint itself is favoring me because it says that the first transaction was made on 30th January 2019. And here I have received money in December 2020, my Ladyship. Where was I in picture in the inception?
Okay. Yes, did you find your Baklat Nama?
Lordship, may I please, Lordship?
Yes.
Lordship, this is confusion, so it may not be proper to make a submission since my power is missing. However,
Yes, because here it is not there.
Not there.
if my
And
Lordship,
in the second copy also, because it's not there, no?
Lordship, in the previous occasion also I have been consistently appearing. So on the power of the Baglat Nama. But however, this is a little confusion if double court go with the record or allowed me to file upon my power, or otherwise, since the
No, since we have already
yes,
heard.
yes, all the records are placed before your Lordship. So.
If he has to say something, I have no objection. Otherwise, my Ladyship.
I think you will be submitting on the same lines.
Same lines.
As the
Yeah.
public prosecutor. The only thing
So
which
the only thing is that
this court
everything,
would like
whatever
to know
the-
is this Shivshang Show, this Amarnath Enterprise, whether there is any explanation in the charge
Nothing.
sheet regarding this.
Nothing. My Ladyship, we can also refer to the.
Regarding
yes.
this, I got clarification
Yes,
from
yes,
the
please.
private respondent that the money has been deposited from the
Yes,
victim's
yes,
account to Sashikala, and then it was transferred to Anand
But-
Kadam. That's what I.
My Ladyship, that does not make me an accused. That too, after 2 years, the money has come up in my account.
And then what about this?
The question is whether the applicant has received the amount. That is.
That is not the question presently, my
He is not
Ladyship.
denying the transaction.
My Ladyship, even if I accept the transaction, it has come up after 2 years, and that too not directly. Through some other person, it has come up. So they might be my known person. I'm accepting that they're my known person. That does not make me party from the inception. It says that from inception, there has to be fraudulent intention. And I have to be involved in that fraudulent intention. No existence has been there, my Ladyship, since January 2019. Everything, even if everything, whatever is written, my Ladyship, in the disclosure, I accept. The victim statement is favoring me, both in complaint as well as in charge sheet. Nowhere she is saying that she has met me.
Here, there is a mention of annexure P16, annexure P18, 19. These are only the bank statements.
Bank statements.
Bank statements.
Receiving money, my Ladyship, how can it be a crime? I'm a business person. I have dealing with more than 200 people. If they are doing some illegal activity, how can I be liable for that?
Those are just a mere submission.
No, but then,
Your
no,
Ladyship
not
will
mere
have to
submissions.
provide a
Your
report.
victim in this case has not taken my name in her 161.
is relevant for question of FIR. Yes.
Heard General Counsel for the petitioner, Mr. Your name?
Vikas Kumar,
Vikas Kumar.
Pratap Khati and Bandana Rai, my Ladyship.
State
I'll give
your names.
Vikas, Vikas Kumar.
Also heard the learned public prosecutor, Ms. Esmere. I'm not showing your appearance. Stop. Hearing concluded, order reserved.
Much obliged, my Ladyship. Much obliged. Thank you, my Ladyship, for patient hearing.
For orders, item number 12.
Send this also. Yes.
May please, Your Lordship. The public prosecutor is to produce a report today, Lordship.
Yes,
Yes,
regarding
in
the
regard-
notice on R2.
Yes, Lordship.
I think this is a POCSO matter.
Yes, my Lord.
Lordship,
Yes.
I'm appearing on behalf of Zimomi, Lordship.
Has it been served?
I have no instructions, Lordship. So this matter can be listed on Tuesday, Lordship.
Lordship, kindly permit me to advance on submissions here. Lordship, this is the 7th occasion when the matter has come up. The court, on all previous occasions, has passed clear orders
Exactly, there is
directing.
some negligence on your part. Why
Lordship,
is this
yes.
happening?
On the last occasion, my Lord Justice Michael had even taken pains to literally narrate how a report was to be filed by the concerned OC. So, Lordship, if the legal services may be directed to represent here, Lordship, I also came across a decision rendered by the Honorable Calcutta High Court where, Lordship, under similar circumstances, some modalities were framed as to how the court should proceed when the victim is not impleaded. So here I have impleaded the victim. However,
normally what happens is, even if notice is served, they don't appear, then we appoint legal aid counsel. Even if they don't appear, if notice is served, then legal aid counsel is appointed. But in this case, the notice has not even been served till now.
Lordship.
That is the problem.
If an amicus may be appointed, Lordship, to assist the case, because the public prosecutor duly represents the case of the victim as it is. And also, Lordship, as stated earlier, on the last occasion and even before that, on 28/10/25 and 2011/25, Lordship, yes. So, Lordship, my case has come to a complete impasse because of the inaction, or rather the incompetence of the concerned officer, my Lord. And on one previous occasion, this Honorable Court had observed that if at all no report was furnished, then an amicus may be appointed, my Lord.
Okay. Learned counsel for the petitioner, Mr. Alezo Kire. The learned public prosecutor, Ms. S. Chang, submits that the matter
on behalf of Vijay
is being dealt with by Mr. Vijay Momi, who is indisposed today. And learned PP also submits that she has no instructions regarding the service report on the respondent number 2. This court on several occasions had granted opportunity to the learned public prosecutor to ascertain the notice on respondent number 2 and to get a report from the OC of the concerned police station. However, till date, the report of notice on the respondent 2 has not been received. This petition was filed on, when did you file? Was filed on 1/8/2025, isn't it? 1/8, yes. Filed on 1/8/2025. And it has now been 4 months since the petition has been filed, and the notice regarding and the notice on respondent number 2 is yet to be served. In view of the delay in the receipt of the report, and in view of the fact that the learned public prosecutor is already appearing for the state respondents, this court hereby appoints, who is there from legal aid? Sintianger. Hereby appoints Mr. Sintianger. You are in legal services, isn't it? Legal aid counsel to represent the respondent number 2. The learned counsel for the petitioner shall supply a copy of the petition on Mr. Sintianger during the course of the day.
Lordship.
Have we called for the records? Records also here, I think.
Yes, my Lord. If a direction may be made for preparation of paper book.
The registry is directed to prepare the paper book as the trial court records have been received. Let the matter be listed for hearing after preparation of the paper book.
I'm deeply obliged, my Lord.
For orders, item number 14.
Please, Lordship. Your Lordship, in this matter, I've been instructed to appear on behalf of the claimants. That is respondent number 1, 2, and 3.
1, 2, and 3.
Yes. So I'll be filing my power within some time, so I may be granted 3 weeks' time to file my power and affidavit in opposition, if any.
Learned counsel for the appellant is present. Learned counsel, Mr. Z. Kulno, enters appearance for respondent number 1, 2, and 3, and prays for 3 weeks' time to file his power as well as to file Objection?
Yes.
This is for condonation of delay.
Lordship.
And to file an objection in the IA 119 of 2025. Stop prayer is allowed. List after 3 weeks.
Obliged, Lordship.
For orders, item number 15.
May I please, Your Lordship? Lordship, I beg to mention on behalf of Indim Song, additional AG, Lordship. Here,
On
I'm yet
behalf
to,
of?
Indim Song,
Okay.
additional AG. I'm yet to receive instructions, Lordship, so kindly grant me some time, Lordship. 3 weeks.
What about the respondents? Are you also filing? I think respondents 13 and 59.
Yes, my lord, we have filed the affidavit.
You have filed?
Yes, on 18/11/2025.
Okay. Learned counsel for the petitioner, Ms.
Kupulisu.
Kupulisu is present. So learned government advocate Ms. S. Jung makes a prayer on behalf of Mr. Im Tim Song, learned additional AG, for the state respondents to allow how much time? 3 weeks to file an affidavit in opposition. Stop. The learned counsel, Mr. Sir and such, appearing for respondents. You are for respondents.
Yes, I for respondents 6 to 13, 14 to 20.
Acha, this long list.
Yes, I'll write
Appearing
and just
for
read it, my
respondents.
lordship. If you
Just write it down and give it to them. Submits that the affidavit has already been filed.
Yes, my
on
lord.
behalf of the said respondents. So for 13 and 59 also.
Yes. For 13 and 59 also, we have already filed on 18/11.
Have you received a copy?
Yes, Lordship.
So, yes. Accordingly, list the matter of the 3 weeks in order to enable the state respondents to file the affidavit in opposition.
To be obliged, my lord.
Obliged, Lordship.
For motion from the supplementary cause list, item number 17.
Lordship, at this stage, I have a very limited prayer. I am being vexed twice for the same offense by the same authority, Lordship. On 24th of February 2022, I was summoned, Lordship, by the Enforcement Directorate.
24 to 2025?
Yes, 2022.
Oh, 22.
Yes, my lord. Now, I appeared on 4th of April 2022. The summons is at Annexure 9, page 138.
Yes.
Now, 139, the dates are being given. The summons was issued on 24th of February.
4th Feb 2022.
Yes, and in the top of the page, third line, at my office on 4/4/2022. The same page, third line.
Same page.
139, yes, third line. Now, therefore, in exercise of the powers conferred upon me under subsection 2 and yes,
To at my office on 4/4/22 at 11 a.m.
yes, my lord. So I accordingly went and attended. Thereafter, the next annexure, page 142, my lord.
Summon under PMLA.
Yes. Directorate of Enforcement has summoned me.
This is the first summon. Then
Then the next annexure, 142.
you appeared on.
Yes,
4th.
I appeared, and adjudication followed. After that, the adjudicating authority found me guilty of the offences, and then my property was attached.
Oh,
That is the 142nd.
142.
Yes. The relevant portion, my lord, if I may be allowed to take my lord to page 186. There was another person along with me in these proceedings.
This is order dated
31st of December 2024. Now the operative portion is at page 186, paragraph 11. Paragraph 11. my lord.
Yes.
I may be permitted to read. It is evident from the perusal of records, including the reasons recorded under Section 8, Subclause 1, by the undersigned that in this case, the alleged criminal activity falling under scheduled offence as enumerated under the PMLA 2022 resulted in generation of proceeds of crime, full stop. However, the Enforcement Directorate was unable to trace the entire direct deployment of these proceeds of crime. Consequently, the ED resorted to the attachment of properties equivalent in value to the untraceable proceeds of crime. As evident from the contents of the original complaint, the following properties attached under Section 5, Subclause 1 as mentioned on 3 of OC and at page 3031 of PAO have been stated to be properties attached as value thereof as detailed thereunder. Now, 1 and 2 belongs to somebody else. This is not mine. 3, the next page, my lord. This is my property which has been attached. Now, the next page, 188th page, the top paragraph, an appeal under Section 26 of the PMLA against this order lies to the Honorable Appellate Tribunal, PMLA. Now, my lord, I have also preferred an appeal before the Appellate Tribunal, yes, which is presently pending. I have annexed the last order, which is available at Annexure 11, which was passed on 8/9/2025.
Yes. Where? Page?
189, the next page, my lord.
Okay.
It's a very short order. The opposite respondents, they sought some time to file some affidavit on their behalf. The time was accordingly granted. Now, after this, my lord.
This is order dated 8 September.
Yes, 8 September. After this, my lord, the matter was listed again on 17th of November 2025. However, the order passed on 17th of November is yet to be uploaded in the web portal of the Appellate Tribunal, which is why I have annexed the cause list, which is at Annexure 12, page 190. Item number 5 is mine, my lord. Now, when all this was pending, my lord, at Annexure 14, this is what I am aggrieved with. Annexure 14, page 197, my lord. The relevant portion is at page 198. I was summoned today, my lord. Yes, it has been postponed, of course. I'll come to that later. But on 28/11/2025 at 10:30 a.m. And the summons was issued on 28th November 2025.
Same case.
Yes, same case. Now the same authority, Enforcement Directorate, Sub-Zonal Office, Dimapur. Thereafter, last evening at 2:30 p.m.
This was issued on 2011.
Yes, 2025. Just a few days ago, my lord. Now I was directed to appear today. However, yesterday, in the afternoon at 2:30 p.m., an email was sent to me saying that due to some exigencies in the Enforcement Directorate office, my appearance has been postponed and I am directed to appear on 4th of December at 2:30 p.m. Yes. Now at this stage, my lord, I am, despite me being vexed twice for the same offense, I am willing to fully cooperate with the investigating agency. It's just that a direction may be given not to take coercive steps against me. That
yes,
is
you
my...
need to appear because maybe they need some further information also.
Yes, yes,
never know.
yes, my lord, my lord. So that is my limited prayer at this stage.
Where's your prayer portion?
Page number 19. It begins from 18 and my interim prayer is at page number 19.
Actually, is this that case in connection with the new High Court
Yes,
construction?
yes. And I'm not even the principal contractor. At the time when the CBI conducted the investigation, unfortunately, the portion of the road, small portion of the road was yet to be completed because of the non-completion of the main High Court building. There was construction materials, construction equipments, machineries, which was lying about, which is why it was decided that only after major portion of the new High Court complex, main building is completed, the road
Now it's
encircling,
completed.
yes, now it is completed. Encircling the main High Court building will be constructed. That portion only remained. However, CBI, for whatever reasons, they conducted a casual and perfunctory investigation so far as I am concerned, and stated that I have withdrawn the entire amount and the road is yet to be completed. It is short by so and so, about 300 meters, 347 to be exact.
Okay. Heard learned counsel for the petitioner, Mr. Cynthia. The present application is filed under section 528 of the BNSS 2023, praying for quashing of
Summons stated
the summons dated 20 summons dated 2011
My lord.
2025
and email,
and
because email is arising from this summons only. It is interconnected. Email dated 27/11/2025.
but in your prayer it is not there.
Yeah, it is there, it is
And
there.
the email
Yes.
dated 27/11/2025 issued by the Assistant Director, Enforcement Directorate, Dimapur Sub-Zonal Office. Stop. The submission of the petitioner is that by a summon dated 24/2/2022 issued under the PMLA Act, the petitioner had already been summoned to appear before the Enforcement Directorate at Delhi.
Yes.
The first one.
No,
The
first one, it was at Gauhati.
At Gauhati, and the petitioner had duly appeared before the Enforcement Directorate on 4/4/2022. Stop. Thereafter, the where does it start? That attachment order page.
Page 197, 186, 186.
No, I just want to see the order date and then the authority.
The order dated is 31/12/2024. The authority is
dated 31/12/2024.
My lord.
The Enforcement Directorate had issued an order of attachment against the petitioner, and thereby wherein it was stated that the petitioner is at liberty to file an appeal before the appellate tribunal under section 26 of the PMLA Act. Stop. Accordingly, the petitioner has filed an appeal under section 26 of the PMLA before the appellate tribunal. Stop. On 8 September 2025, the matter was taken up by the appellate tribunal, wherein the respondent authorities took time and were granted
8 weeks.
Granted 8 weeks time to file a reply to the appeal of the petitioner. Stop. The matter was accordingly listed on 17th November 2025.
The next date is about to be listed on 3rd of February 2026.
Acha, listed on 17
Again, they sought
November
time.
2025, on which date more time was sought by the respondents, and the next date fixed is 3/2/2025 or 2026. Stop. Para. Well, matters stood thus. The petitioner received another summon in the same case from the Enforcement Directorate by the impugned summon dated 20/11/2025, requiring him to appear before the
Assistant Director,
Assistant Director,
Enforcement Directorate, Sub-Zonal Office, Dimapur.
Sub-Zonal Office, Dimapur, on 28/11/2025 at 10:30 a.m. Stop. The date has, however, been postponed, and the petitioner received an email from the Enforcement Directorate, Zonal Office Dimapur, Sub-Zonal Office Dimapur, stating that the date of his appearance would be 4/12/2025 at 10:30 a.m.
At 2:30 p.m., my lord.
Oh.
Yes.
Okay, at 2:30 p.m. Stop.
10:30 is another person.
Oh, at 2:30 p.m. Stop. The petitioner is therefore before this court, praying for direction to quash and set aside the impugned summon dated 20/11/25 and the impugned email dated 27/11/25. Stop. Para. Issue notice returnable within 4 weeks. The learned counsel for the petitioner shall take steps for service of notice on the respondent number, on the sole respondent.
Yes.
By how? Speed post?
Yes, my lord.
By speed post document as well as usual process within 3 working days. Stop. List after 4 weeks. Stop. In the interim, the respondent authorities are directed not to take any coercive steps against the petitioner in connection with the impugned summon dated 20/11/2025 and the impugned email dated 27/11/2025. Stop. However, it is made clear that the petitioner shall appear before the respondent authority as summoned.
I am deeply obliged.
Then 2 and 3,
2 and 3 here,
same.
they were summoned, but there was no proceedings was initiated against them. And after
No attachment.
no proceeding was initiated. And they were summoned on 24th of February 2022. And after more than 3 years, they are summoned again on the same set of...
No. What I mean is the facts are the same as
Yes,
the first petition.
yes, the facts are the same.
And they also appeared on 4/4.
No, they were... The date of summons is different, and the day on which they were directed to appear
That
is also different. It's also different.
Acha. Same order, but you just go through the other petitions. The dates only will be different, okay?
Annexure 9.
And
Annexure
then
9.
in the other two, there was no attachment,
Yes,
isn't it?
yes.
So you leave out that attachment portion and just type out the rest. And regarding impugned order, same date.
Yes, same date.
Same date, timing is different, isn't it?
Timing is different, yes.
So there also timing will be different. His is 2:30, others are I think 10:30, 11:30.
And 12:30. Yes.
So you just go through the petition.
41 is 12:30, and 42 is 10:30. Same day. Deeply obliged.